Welcome to Oil and Gas Law with Energy Law Prof. We're going to talk about another constructive production savings clause today, the cessation, dry hole, or continuous operations clauses. We'll see that there are different ways that these clauses can be written, and we'll see that they have, in some ways, grown more complex over time. Okay, so these can be the same clause, can be different clauses, but here are some of the key terms that you will see describing these clauses. One is a cessation of production clause that tells you what the lessee, oil and gas company, has to do to maintain the lease if production ceases, often unexpectedly for some reason. We'll talk about a dry hole clause, which is what happens if, at the end of the primary term, that oil and gas company is drilling for oil, and it turns out there's no oil there, but it's quite sure there's oil somewhere on the property, and so it wants to just keep drilling, drill another well. And then we'll talk about the operations clause, which basically says, as long as we're working on it, working towards providing or restoring production on this lease, we should be able to keep the lease. Now, temporary cessation of production described on page 257 in your book. This is actually an implied term of the lease. So although the lease says that you only get to keep that lease as long as oil and gas is produced, that doesn't mean that if it literally stops for some unexpected reason one day for a couple hours, the lease immediately ends. So the lease doesn't immediately terminate because production ceases. Instead, the courts have said that they'll consider a few factors. One is obviously the duration of the cessation. So if it just stops for a few minutes because something got stuck in the wellhead, that's not a problem. But if it's a longer stoppage, weeks or months, that could be an issue. Another question they'll consider is, did the oil and gas company, the lessee, do everything it could to try to restart production as quickly as possible? And then, of course, they'll look at what's the cause of the cessation, right? Imagine that well froze up and wasn't able to produce. Was that something that was really unpredictable because it was an unpredictable freeze or a failure of power to the well that was not expected? Or was it because the oil and gas company really didn't take proper precautions? So when the courts consider this implied doctrine that temporary cessation won't stop the well automatically, they're going to consider these factors to decide, is this really just a temporary cessation of production, or was this a longer cessation of production? Production stopped for long enough that the lease should end. Now, there are some limits on that temporary cessation doctrine. Here from a Texas case, they said in this case that the event that stops it has to be necessarily unforeseen, that results in a sudden stoppage of the well or a mechanical breakdown of equipment or something like that. Then what's happened moving forward is that oil and gas companies have now written into their leases a cessation of production clause that sort of replaces that temporary cessation doctrine that was just implied and can be more explicit about what can be used to extend or stop the lease. So here is a typical dry hole cessation operations clause. It's going to sound very complex, but I can tell you what actually makes it typical is it's much shorter than the typical clause. And just for simplicity's sake, I've given you a very abbreviated version, much shorter, for instance, than the version in the Producers 88 lease I gave you. And we'll talk about why this got so long and convoluted. But I'm going to read it to you first. If prior to discovery of oil and gas or other hydrocarbons, the lessee should drill a dry hole, or if production should cease from any cause, the lease shall not terminate if lessee commences additional drilling or reworking operations within 60 days, or if it's within the primary term, commences or resumes the payment or tender of rentals. If at the expiration of the primary term, oil, gas, or other hydrocarbons are not being produced, but the lessee is engaged in drilling or reworking operations, the lease shall remain in force so long as operations are prosecuted with no cessation of more than 60 consecutive days. Okay, let's look at how this kind of clause would apply in a case. We're going to look at Rogers versus Osborne, page 261 in your books. It's a Texas case, 1953. So in this case, the first well had no actual production. So you might think, all right, I can rely on that dry hole clause. You may remember that from the example clause we just went through. If you drill a dry hole, you have 60 days to drill some more. Well, unfortunately for the lessee, the oil and gas company, the jury said, no, this wasn't a dry hole. There actually may have been oil and gas in it. Okay, well, what about cessation of production? If there was cessation of production, again, the lessee oil and gas company would have 60 days to do some more drilling. But here, there was never any production. So although it wasn't dry, it maybe had oil and gas, there was never any production from it. So the lessee can't rely on the cessation of production clause. Did the lessee pay shut-in royalty? No. And in fact, it couldn't, because although it wasn't dry, it was actually not capable of producing. So shut-in royalty wouldn't have been valid. All right. Well, the lessee did drill another well. So is that okay? Although the next well was drilled immediately after this first well that they were never able to gain production from, can that extend the lease? Well, the court says no, because they say that this second well isn't drilling or reworking operations. Well, that's a little puzzling. Sounds like a second well would be drilling. Why does the court decide that? Well, it has to do with the wording of this dry hole cessation operations clause. So let's look at these two sentences and how they differ. So first it says, if we have a dry hole or cessation of production, then the lessee can commence additional drilling or reworking operations within 60 days. But then it says, if at the end of the primary term, there are no oil and gas, which was a situation here, because it wasn't a dry hole and it wasn't cessation of production, then as long as the lessee is engaged in drilling or reworking, the lease shall remain in force. Okay. Now, looking at those two things, you might have said, well, those are basically the same. So what's the problem under that second sentence, since that describes what happened here? There was no production at the end of the primary term. Here's the problem. That word additional. So for the dry hole and cessation of operations clause at the beginning, it says you can do additional drilling or reworking. But for the no production at the end of the primary term, it just says drilling or reworking operations. So in that case, it doesn't use that word additional. And the court says that's key here. Here, you could keep drilling or reworking the same well, but you can't do additional drilling of another well under this clause. All right. So effectively what the court is saying is that this is more of a well completion clauses that permits the oil and gas company to complete a well that it already began during the primary term. This is not a continuous operations clause that says, oh, go ahead and drill whatever other wells that you want as long as you don't stop for more than 60 days. Potentially a harsh result, and you'll see that one reason that the cessation of production clauses has got so long is because there are these technical ways that you can lose in front of the court, because as you can see, they can interpret them pretty harshly against the oil and gas company. And so sometimes one way of dealing with those adverse course decisions is every time you get a bad ruling, just add another sentence to that cessation of production clause, the operations clause, well completion clause, whatever you want to call it. You could add another sentence trying to change the result in the circumstance that you lost this court case in. And that can lead to cessation of production clauses that are not very elegant. Now, a potentially more elegant way to handle this would be through a continuous operations clause. And that is basically a clause that just says, look, if for whatever reason the lease would otherwise expire, but we're working on trying to get production, that should be enough to maintain the lease. So here's a continuous operation clause. If at the end of the primary term or at any time thereafter, the lease is not being kept in force by any other provision hereof, but is then engaged in drilling or any other operations calculated to obtain production on the leased premises, this lease shall remain in force as long as the same or any other such operations are conducted without an interruption of more than 60 consecutive days and if such operations result in the production of oil or gas, as long as production continues in paying quantities. So this provision just says, look, as long as I'm working on it and never stop working on it for more than 60 days, I get to maintain this lease. Okay, there's a couple terms. It's helpful to see how the courts have interpreted them. Reworking, you saw that term. Reworking means any and all acts, work, or operations which an ordinarily competent operator under the same circumstances would engage in a good faith effort to cause a well or wells to produce oil or gas in paying quantities. So, you could recomplete a well, you could, clean out a well, you could frack a well. There's a lot of things that you could do to try and get a well to produce that for whatever reason stopped producing. Okay, operations for drilling, when that's required, note that that qualification for drilling means that anything other than drilling is not going to work here. So just normal reworking or operations won't work if what is specified is operations for drilling. So throughout with these I'm working on it clauses, whether there's cessation of production, dry hole clause, or a continuous operations clause, you can see how the courts can interpret these pretty literally to end a well and why it puts such a premium on carefully drafting those clauses.